And if one person is on the phone with another person and they record the other person on the phone without telling them that they're recording, is that legal in Nevada? Hi, I'm Emily McFarling.
My name is Brian Reardon.
And we're here to talk about the discovery process in family court in Clark County, Nevada. I am the managing partner of McFarling Law Group. I'm the president of the Nevada chapter of the American Academy of Matrimonial Lawyers, and I am a practicing family law attorney, and my practice is mostly in appeals.
I work with Emily at her law office, and I'm a former prosecutor. I mostly focus on divorce and child custody matters.
So why don't we start out by just talking about what discovery is?
So I like to view discovery as just a set of tools that's available to litigants as they're going through the process of litigation. Whether it's a divorce or a child custody matter, you really need a set of rules that are there that everybody's going to follow. So instead of looking at these as hard specific rules, you kind of look at it as tools that are available to make sure that all the parties are receiving the same type of information, because we really want people to be on equal footing as they go through this process. The rules are governed by Nevada Rules of Civil Procedure. For family law, they have their own set of rules that's starting at 16.2. And that's what's called the initial disclosures that are required as a married couple are going through a divorce. However, if you're unmarried and there's a child custody matter that's in dispute, then there's a separate set of rules that requires different information for those parties. And then let's just say that you resolve this issue, a child custody matter that was contested, and a couple of years later you want to reopen that. There's another set of rules that govern that process as well.
And what's the specific rule that applies in an initial divorce case on what people need to disclose or how they need to handle themselves in discovery in family court?
So in family court, that's Rule 16.2. And then for the custody matter, Rule 16.205 and Rule 16.21 for modification of some former ruling. So all this information that needs to be exchanged between the parties, what are you actually required to disclose for a married couple going through a divorce?
So in an initial divorce proceeding, the parties, there's this very long list of documents and information that each party is required to disclose. They don't have to be asked for it. They're actually required to proactively disclose it very early in the proceedings. And that would include documents that are going to show the identity and the value of any property or debt they have. And it gets very specific into bank accounts, vehicles, houses, credit cards, loans. It's a very specific list. The time period it looks back is 6 months prior to the complaint for divorce. And it really spells out the basic things that in any divorce would need to be looked at and divided as community property in the divorce itself. In addition to that, people are required to file a financial disclosure form very early in the proceedings. In that form, they have to detail out their income, their expenses, all of the property they have, all the debt they have, how much attorney's fees they've paid or are still owed to an attorney at that point in time, and really spell out their financial condition.
Is that the same for, say, two parties that share a child in common but are not married?
So the information that's required to be disclosed in an initial custody case is certainly much, much less. It really revolves around the child, and income information, of course, is what's most relevant financially when you're dealing with custody and child support cases. And then on the financial disclosure form, if it's just a custody case, whether it's an initial custody case or a post modification or enforcement case, then you don't need to fill out the property and the debt sections of the financial disclosure form, the expense sections, because really they're looking at what is your income for child support purposes if it's custody and child support that's at issue.
How long do you have? Seems like a lot of information you have to gather, certainly. So how long would you have if you were going through, say, somebody files a divorce against you? How long do you have to provide that financial disclosure form?
It's pretty quick. The time periods start to run as soon as the complaint is served on the other party. Then these time periods start to tick for you to do disclosures and to file financial disclosure forms very early, because the goal is that you want people to disclose this information that they already have. They should have easy access to, so they can exchange this information and people can start working towards a resolution or building their case for trial early on without there being a lot of delay where people have to ask for it. In the discovery process, so once discovery opens, aside from the financial disclosure form and the required disclosures, are you able to ask for additional information from the other party in the case?
That's a great question. Yes, the rules allow that you could ask for additional information that's normally served on a party through what are called written interrogatories.
And are you able to ask for documents as well?
Yes, you could request production of other documents that you think are relevant to the proceeding as well.
And admissions, what are those?
So you're going to receive requests for admissions from the other party. And so that's when you look at what they're asking you and you want to either say it's either true or false, basically whether you agree or you disagree with what they're asking you.
And if somebody doesn't respond to a request for admissions, and it's a 30-day deadline to respond to those, if someone doesn't respond to them, they have an extra high sanction compared to like documents or interrogatories, because the court can go in and deem them admitted. And so when you're crafting admissions, you want to make sure that the requests, you're asking them to admit things that would hurt their case or help your case. So you want to kind of go in and craft these admissions so that if they don't respond to them and they're deemed admitted, that those are the admissions that really, the facts that really make your case for you. So we have admissions, we have interrogatories, we have document requests that are all sent out to the other party, and they have 30 days to respond to them. What happens if somebody, aside from the admissions issue that I just mentioned, what happens if somebody doesn't respond to the document requests or the interrogatories?
Certainly, you can't simply ignore these requests, right? It's litigation that is ongoing, and the court is overseeing some of this. So you could request what are called sanctions, and that's kind of what you talked about earlier, that if you don't respond, then the court would just deem that what you're requesting is already admitted. So the court can order sanctions against a party that is non-responsive to these requests.
And that process starts with somebody filing a motion to compel, saying, hey, we served these requests, they didn't answer them within the 30 days. There's some additional requirements where you have to have a meet and confer, you have to really address, and have discussions with the other side. And you can do this not just if they don't answer, but if their answers are deficient as well. So they only give you some documents, they give you kind of vague answers on the interrogatories. You go in and file a motion to compel once you've kind of exhausted all the communications that are required. And the court will then go in and make a decision on that request, which would be, if it's granted, compelling the other side to actually answer. So if you get a motion to compel granted and the court has compelled the other side to answer them, then if they don't, then you're really left going, okay, now what do we do, right? This is, okay,
Sure.
We have an order that says, okay, you're compelled. And so we get into the adverse inference sanctions, the admissions deemed admitted sanctions, which is automatic. You don't have to file a motion to compel for that, although a lot of people do. And then you have to figure out how to use those sanctions at trial. When you do end up going to trial, what do you do when you've gotten a sanction of some fact being deemed adverse to the other side because they didn't actually respond to the requests for that?
So there's certainly some incentive there. And what would you see happening, say there is a sanction that is imposed by the court? Could it end a case just outright?
So we have case law on child custody cases.
Sure.
That if someone doesn't participate in discovery and is really not responsive and involved in a child custody case, you cannot go in, the judge cannot go in and make a case concluding sanction against the non-participating party in a custody case, because they still have to look out for the best interest of the child, no matter what. So you can't have a sanction that's so severe that the judge doesn't get to then hear evidence and make a determination that's best for that child. And that case is called Blanco. That's very clear on the child custody situation.
Makes sense. It seems that it protects the parents' procedural due process rights at that point then, right? They get an opportunity to come back and heard the case have their case heard on the merits, right?
Yeah, and I think the idea is that it's protecting the kid. So even if
Sure.
you have a parent who's not doing everything they need to do in the legal case, the court is still looking out for that child no matter what. That's their goal. And in divorce cases where you're dividing community property, if you have discovery that's not responded to, no matter what, the court still has to follow the law on the division of community property. So the judges are required to divide community property equally unless there's unusual circumstances. And so if you have someone who's not participating in discovery, that alone shouldn't get around that requirement that the property be divided equally, although it might be difficult to ascertain what there is if
Sure.
someone's not providing information or documents to identify the property they own or show the value of it. Ultimately, the judge still has this obligation to divide it equally, unless there's unusual situations. So discovery sanctions in divorce cases often will be where you have a claim of waste or a request for an unequal division, or looking at someone's income. If someone's not disclosing their income, we're trying to calculate child support, we're trying to calculate alimony, and so the court can go in and make adverse inferences or have sanctions on those, that type of information if the other side is hiding it, is not disclosing what they need to in order for the court to 100% accurately calculate what their income is.
So when you're going through a divorce or child custody, are you able to receive information from different parties?
So in order to get information or documents from people who are not a party to the litigation, third parties, there's two different mechanisms that you can use. One would be to send out a subpoena to that third party, which is basically a court document that requires that party to give you documents that are responsive to it. And the second one is to conduct a deposition of the third party. So when you send a subpoena, the process requires that you send notice to the other party first. You give them a period of time to object to the subpoena. So before it's even sent to the third party, the attorney or the opposing party in your case actually gets this opportunity to say, no, you can't ask for those records. Maybe they're privileged. Maybe they're beyond the scope of the case. They're not relevant to the case, something like that. And then if they don't do an objection, or if they do an objection and the court confirms that you can get those records, then you send the subpoena to the third party, and they're then obligated to respond and provide those documents. Sometimes a third party will get an attorney to assist in objecting to a subpoena or clarifying it as well. And so that's something that the third party can do when they receive a subpoena to provide records in a case. But generally, if the other party hasn't objected to it, the subpoena goes out to the third party. It's for records that are relevant and appropriate to be provided in that case. And so that third party has to provide those records within a certain period of time that's spelled out in the subpoena. For a deposition, you would send a notice of deposition to the third party, and it sets a date and time for them to show up at usually the lawyer's office or a deposition facility. And they sit down in a conference room. There'll be a court reporter there that will transcribe the deposition. Sometimes people do video depositions where they take a videotape of it as well. And it can go on throughout most of a day where the lawyer's asking questions. The third party, or if it's the party's deposition, the other party, has to answer the questions. They're sworn under oath to tell the truth, just as if they're in a court of law. And they go through and ask questions. And at the end of it, the other attorney is allowed to ask some questions as well if they want to clarify something that was said during the deposition. And then that deposition process results in a deposition transcript that is, an official record. It's sworn testimony. And at the trial, if you have someone's deposition transcript, they're testifying on the witness stand. One of the most common uses for the deposition is to impeach the credibility of the person on the witness stand. So let's say they say something on the witness stand that is inconsistent with what they said in the deposition. You can then publish the deposition during the trial and have it shown that that person is not credible and that they're lying. So that's the most common use of a deposition, in addition to just getting information during the discovery process, finding out the information. So is it possible to ask for the other party in a family court case to submit to a medical or mental health examination by a medical provider?
Yes, you can. Rule 35 governs that and how that is actually how that is actually done. So if mental health is a concern, one of the parties that maybe is going through a divorce or a child custody matter, maybe it has some deterioration in her mental health, you could, under Rule 35, you can motion the court and request that. And so the court is going to look at whether or not the mental health is really in controversy there. So if you have somebody that is under the care of maybe a mental health provider and is not taking their medication and is not able to perform the day-to-day activities with the children, oversee them, or participate in parenting decisions, then the court can actually order that person to have a mental health examination.
And in our child custody statutes, we have this list of best interest factors that detail all of the things that the court should look at when they're making a child custody determination. In that list, is it are mental health and physical health issues something that the court is required to look at in each child custody case?
It is, yes. That is a specific factor that the court is required by law to look at.
And I'd say that, often you have people who want to object to these kinds of examinations, or, that's private. You can't get my records, my mental health records, or you can't get me evaluated for mental health. But the reality is that because it's in the list of best interest factors, it's always relevant to a child custody proceeding. And so you can't, coming in and saying, well, that's not relevant. It's spelled out in our statute that that's a relevant factor that the court is required to take into account when it's making a determination on child custody.
Great point. We want to make sure that the parent that's overseeing a child is actually fit and proper to render care for them. So Emily, are there any other situations besides a custody matter where you'd want a mental health or physical evaluation done on the other party?
So when somebody's asking for alimony or spousal support, one of the things that the court can look at is whether or not they have a disability or their ability to work. And so if someone brings up an issue in their request for alimony or spousal support that they're not capable of working, that they have some sort of disability, certainly that would be a situation where you could go in and have them evaluated if that claim is something that you're not confident is legitimate, and you want to make sure that it really gets fully vetted, that person has some kind of disability or difficulty working.
So Emily, we're certainly living in a connected world these days. So these cell phone devices that everybody seems to carry around, are they subject to these rules, and can they be examined?
So that's a great question. Our rules are, they're written a long time ago, so they deal a lot with asking for documents, asking questions. But the document production rule of the Nevada Rules of Civil Procedure also allows for examination of things. And so you can go in and ask through the discovery process and through the discovery rules to examine things as well. And that can include electronic devices. So you can go in and what I do is hire an expert, a computer expert, to have on deck. You go in and ask for the person to produce their cell phone, to produce their laptop, to produce their desktop computer, any other kind of electronic device that has data on it, to produce those, bring them to the office kind of like they would come for a deposition. And then we have our computer expert make a copy of it. Sometimes there's objections, to, how much information can you get off of someone's computer or phone device that might go through the court to limit the scope or make a determination. So I've had cases where the judge has said, okay, you make a copy of it, but the computer expert has to hold on to it and filter through the data and can only provide, information that fits a certain criteria. Like, let's say we're looking for photos. So, okay, we make a copy of the device, but the computer expert can only provide me with the photos that are on the device. Or if we're looking for emails, we're looking for communications, they can go through and, only provide me the emails, or maybe even limit it so that the emails only if they contain certain words, certain keywords in the emails. And so the court can be pretty protective to make sure that you're not just getting a complete copy of everything on their device, but it's targeted to exactly what you need. But you can also look at things like, did this person go in and delete a bunch of stuff? Is there you send out the notice to examine their computer and all of a sudden it's wiped out, right? So that certainly would be relevant to some discovery claims as well. So it's certainly something that can cause a lot of debate when you go in and ask to examine someone's electronic devices, but absolutely you have the ability to do it in the discovery process.
So if somebody's deleting information off their device, could that lead to those sanctions we talked about earlier?
Yes, if someone goes in, you ask for their computer, they wipe it out. You could go in and ask for an adverse inference for the court to determine that anything they deleted would have been adverse to them, or anything they didn't produce would have been adverse to them because of the fact that they didn't disclose it. And certainly more proactive acts such as wiping out a computer, are much bigger deal than not providing something they may not have access to. So certainly wiping out a computer after you've been asked to make a copy of it can look really bad. And computer experts often can go in and find that data anyway.
Good point.
Too. So a computer expert might be able to go into a wiped out computer and recover what was deleted if the person who did the wiping out of it didn't really do it as fully as they needed to. So you want to be careful.
Digital footprint, stay with us.
Yeah. And in fact, that gets to the issue of if you have something that's discoverable, you're in a court case and you get rid of it, let's say your Facebook account has a bunch of posts on it that make you look really bad, and you go in and delete them all. Delete all the Facebook history that looks bad for you. Actions like that can be looked at as tampering with evidence as well. So you want to be really careful when you go in and delete things or get rid of things when you're in a family court case or any type of court case, because it certainly could hurt the fact that you went in and did it. So Brian, when two people are sitting together in the same place and one of them records the other one, is that legal in Nevada?
Yes, as long as one party to the conversation consents to it, then you can record that conversation. Nevada is called what's called a one-party consent rule. So as long as one party to the conversation consents to it, say I'm recording us and you don't know about that, as long as I'm consenting to the recording, then you can go ahead and do that.
And are recordings like that admissible in evidence in family court?
If one person consents to the recording, yes, it is.
And if one person is on the phone with another person and they record the other person on the phone without telling them that they're recording, is that legal in Nevada?
So that's a federal crime, actually. So you're not allowed to record a telephone conversation over the phone without the authorization to do that or consent to do that.
And if you were to send a recording device, say with your child in their backpack to the other parent's home, or any situation where the person who's actually recording isn't present, is that legal in Nevada?
No, it is not. So if the situation is where two people are having a conversation and neither party consented to that conversation being recorded, then that is not allowed.
And would a recording like that be admissible in family court?
So it's not per se admissible, but it can be used. And there was a case here in Nevada that clarified that for the state. So the facts of that case were that mom and dad were sharing custody of the child, and dad was concerned about some of the conversations that mom was having with the child when he wasn't around. He felt like he was being alienated from the relationship with his child based on those conversations. So he took a recording device and actually placed it in the child's backpack. And while the child and the mom were together having a conversation, they didn't know this, but their conversations were being recorded, and neither of them consented to that. And so when dad received that recording device back, he got the recordings, actually went through and scrubbed them a little bit. He deleted the parts that he didn't think were relevant to the issue, and actually deleted the original copies as well. And so at trial, he moved to admit those recordings into evidence, but the judge denied those recordings being admitted. However, there was a psychologist that was appointed by the court that was working with the child to figure out what was the best interest for the child for this custody determination. And so the court actually allowed the psychiatrist to use those recordings and listen to the recordings. It was an unfettered conversation between the mom and the child, and the court felt that those were relevant to the child's best interest. And so the expert used those recordings informing his opinion. And so that was the issue that was taken up on appeal to the Nevada Supreme Court. And the Nevada Supreme Court, when looking at the case, they reasoned through this and said, certainly that unfettered conversation that the mom had with their child about some of the things that were going on with the father were definitely relevant to the best interest determination. And so they did not find that there was an abuse of discretion by allowing the child psychologist to listen to those recordings and rely on the recordings to render an opinion. However, they did distinguish this a little bit. They put a little warning out there for all the parents that to record someone's conversations without them consenting to it is actually a crime. It's a Category D felony. They said that could be used against the father or the recording party in the determination, but they said it was allowed for the child psychologist to listen to and render an opinion on that.
And I believe, in fact, they also went further to say that even though the judge had not admitted the recordings directly into evidence, that would have been fine to do, that they would have been allowed into evidence because the criminality of the recording and the admissibility of the recordings into evidence were not one and the same. So you can admit something that's illegal, but you just have the risk of getting arrested and being criminally charged if you do it. So certainly not something that you want to jump out and do.
Sure. Yeah.
One other issue that came from reading that case and kind of thinking about where do you draw the line is, if it's one party has to consent to the recording, you're sending a recording device in a child's backpack. Okay, that, a 10-year-old child probably can't consent to that, especially if they don't know about it. But what if you have a 15-year-old child who knows the recording device is in her backpack and is knowingly taking it over to the other parent's house, and when those conversations are occurring, one of the parties to the conversation has given consent but is a minor? I don't think we have an answer on what the court would do in that situation, but it certainly leaves a lot of what ifs and gaps in this arena. So what advice would you give somebody who is going through the discovery process in family court without an attorney?
Without an attorney, it can be really difficult to navigate everything that needs to happen in a family court case. Certainly there's places here in Las Vegas locally where you can go and seek some help. Legal aid centers, Southern Nevada, there's a self-help center where you can go and get information so that you become familiar with the court process. But I think one of the most important things is to participate in the proceedings, right? You don't want to be non-responsive to the court's orders. You want to go in there, you want to be engaged, you want to follow the proceedings as they're happening. There's going to be certain deadlines that you need to meet. And just because you're representing yourself, the court necessarily isn't going to give you any extra flexibility in meeting those deadlines. Certainly the court understands when parties aren't represented by attorneys, they're a little bit more flexible in helping them out, but there's some rules that are set in statutes that are pretty specific as far as timelines that the parties are going to need to follow.
So I would make sure that they follow the rules. And in order to do that, because the rules are so specific, you really need to know what those rules are. So if you're not working with a self-help center or somebody who's kind of walking you through the process, then you really need to go in and read the rules. The Nevada Rules of Civil Procedure, that's 16.2, 16.205, 16.21, that apply to the disclosures and discovery specific in family court cases. But additionally, there's an entire section of the Nevada Rules of Civil Procedure that are about discovery, and it's a whole set of rules, and you really want to go through and read all those and make sure that you know when and how you can do discovery requests, when and how you can send subpoenas, when and how you can send deposition notices, things like that. If you're going to be proactive in the process, or even if you have to respond, so you need to know, okay, when do I need to get these responses in? What's going to happen if I don't do it? Those kinds of things. So make sure you know the rules if you're going to be navigating it yourself.
Great point. And there's another set of rules if you actually go to trial too, right? The rules of evidence that they'll need to be familiar with as well. So it can be a little overwhelming for people navigating that process without an attorney. So post-proceeding, is discovery opened during that time?
So if you have a case that already had a divorce decree or a final custody decision or some kind of final order, and people are going back to modify or enforce something in that order, there's a very specific rule that applies to that. It's NRCP 16.21, and it spells out when and how discovery gets opened, because in our initial proceedings it's pretty clear and there's time frames and it's automatic, but in post proceedings it's not automatic. So if someone files a motion to modify custody, enforce custody, modify or enforce other provisions, they end up having a hearing. At that point in time, discovery doesn't necessarily open either. So there's two situations where discovery gets opened in those post proceedings. One is if the judge sets an evidentiary hearing on the person's motion. When the fact of the judge setting the evidentiary hearing, that opens discovery. So at that point in time, you walk away from that hearing, or maybe it's a minute order. At that point in time, you can start doing discovery. The other situation would be if, say, the judge isn't sure they're going to set an evidentiary hearing, or there's some scheduling issues, but they certainly want to open things up enough for people to do some discovery. They can actually specifically order that discovery is opened as well. And situations where that might happen, maybe there's one thing that they really need to find information about, so the judge might open up discovery on a specific thing. Let's say, go find out how much money he actually makes, and then we'll come back and I'll set child support. And so maybe they don't need to have an evidentiary hearing because they can just set child support once that income information is discovered. Or maybe they go and open up discovery fully and come back and there's some reason why an evidentiary hearing doesn't then get set afterwards. So it really has to be either an evidentiary hearing set or specifically ordered by the judge. Discovery is being opened today. Thank you so much for joining us.
Thank you.